Chapter 10 The Law of Contract. Which one of the following is not a requirement to establish misrepresentation in contract law? The assertion must be in writing. Which of the following statements concerning a corporation's capacity to contract is true? Any person may ascertain the legal capacity of a corporation to contract by reviewing its incorporation documents maintained at its official records office. Which one of the following statements about the revocation of an offer is true? Unless consideration is paid to keep an offer open for a specific time, revocation can be made at any time prior to acceptance. When a contract is executed under seal, the seal stands in the place of consideration. On March 7th, Allen contracts, in writing, to sell his home to Bob for the price of $100,000. The sale is to complete on March 31st. Unknown to either Bob or Allen, the house was destroyed on March 6th. Accordingly, there has been a common mistake. Which of the following is false with respect to the law of contract? The burden or liability under a contract may be assigned, provided that the requirements of the Law and Equity Act are met. Which of the following will not serve to discharge a contract? A patent defect. The essential distinction between a defect and a stigma is that a stigma's effect on property value depends on an individual's subjective considerations, whereas a defect's impact can be objectively determined. In which of the following scenarios has the offer not been released or expired? The offeror decides to revoke their oral offer and mails a written revocation to the offeree, which the offeree has not yet received. An invitation to treat is a request for offers. In which of the following situations will a contract with an infant be enforceable against the infant? The contract is enforceable against the infant in all of the above situations. Charlotte offered to sell her property to Dennis for $180,000 by email. Dennis emailed, "Send lowest cash price, will give $165,000 cash." Charlotte replied, "Cannot reduce price." Dennis then accepted the original offer, but Charlotte refused to sell, claiming that there was no contract. Which of the following statements is true? Charlotte's reply to Dennis' first wire was, in effect, a counteroffer on the same terms as her original offer. Garfield, a licensee, was representing a seller, Madison, in the sale of his house to Tyler. After the sale completed, Tyler discovered that the main and lower floors of the house sloped. Garfield, Madison, and Tyler had not noticed this before, although the defect was discoverable using ordinary diligence. Based on the above, which of the following statements is true? Neither Garfield nor Madison are liable to Tyler for failing to bring the defect to Tyler's attention. On June 1st, Jim offered to buy Boo's summer cottage for $230,000, and Boo accepted. Since the cottage was on a secluded island, neither party was aware that on May 30th, the cottage was struck by lightning and completely destroyed by fire. Boo has no insurance and is seeking to enforce the contract. Which of the following statements is true? This is an example of common mistake and the contract is void. A counteroffer has the effect in law of terminating the original offer so that later it cannot be accepted. A subject to clause in a contract of purchase and sale is correctly known as a condition precedent. Which of the following is not one of the three essentials for the formation of a binding contract? Deposit. On January 1st, Abdul placed an advertisement on CQXR radio station offering squash lessons for $30 per hour. Lois heard the ad and phoned Abdul on January 3rd and said, "I want to take squash lessons, but I'm a student. Do you give a lower rate to students?" Abdul said that he only had one rate of $30 per hour. Lois said she would phone back. On January 5th, Lois phoned Abdul and said she accepted Abdul's offer. Which of the following statements concerning Abdul and Lois is true? Lois' January 3rd call was a request for information and Abdul's response on January 3rd was an offer. Joe, a storekeeper, asked Harry, a courier, to deliver some groceries for him, which Harry did. What is the result? Harry could recover a reasonable amount from Joe for his services under the principle of quantum meruit. Which of the following is false? Specific performance is not granted in a contract for the sale of property if the property is unique. Sally contracted to purchase sewing machines wholesale at $100 each, with a delivery date of November 30th. The wholesaler did not deliver the machines until December 31st. Sally had a buyer on November 30th willing to pay $250 each for the machines, but by December 31st the value had dropped to only $75 each. Which is Sally's best remedy against the wholesaler? Damages. Bob and Margaret execute a contract under seal. Which of the following is true? Because of the seal, there is no need for consideration. If an offeror who has stated that the offer is open for 24 hours decides to terminate the offeror must communicate any revocation of the offer to the offeree. On May 3rd, Mary offered to buy Harvey's house, and the offer was stated to be open for acceptance until 2 p.m. May 4th. Which one of the following statements is false? Mary's offer represents an option agreement. Where no time period is stipulated in an offer, the offer will lapse after a reasonable time. Latent defects are defects that are unknown to the buyer and that are not discoverable upon a reasonable inspection of the property. Which one of the following is not a required characteristic of an offer? It must be made in writing in order to be enforceable against the offeror. Which of the following does not relate to the topic of contract law? Depreciation. A revocation of an offer is effective when it is communicated to the offeree. Which of the following is not an example of a breach of contract? Don contracted with Tony to buy his car. The night before Don was supposed to pay the price and take the car, the vehicle was struck by lightning in Tony's driveway and destroyed. Equitable remedies are remedies that are within the court's discretion to award. Which of the following is not an equitable remedy? Damages. Zelda was in a good mood one day, and she went over to her next-door neighbor Herb's house and cleaned all his gutters. When Herb returned home from work, he was thrilled by what Zelda had done, and he said, "Zelda, I am going to give you a case of wine for doing this." Weeks passed, and finally Zelda asked Herb when she could expect to receive her wine. Herb said that he had changed his mind. Zelda is now furious and wants to sue Herb in small claims court for a breach of contract. Which of the following statements is most relevant to these facts? Past consideration is no consideration. The court will not normally grant the remedy of specific performance where damages are considered to be an adequate remedy. Scott, the fee simple owner of Blackacre, registers an easement over a neighboring property, Whiteacre. Sven, the fee simple owner of Whiteacre, subsequently sells Whiteacre to Alice. Which of the following statements is true? Because privity of contract does not apply to contracts creating an interest in land, Scott may enforce the easement against Alice. Bernadette offers to purchase Steve's home for $438,000. However, before Steve has a chance to respond to the offer, Bernadette advises that she is withdrawing the offer. Which of the following legal terms describes what has occurred? Revocation. Frank sends a letter to Joe saying, "I will sell you 200 dozen widgets for $1,200. Before Joe receives the letter, he sends an email to Frank offering to buy 200 dozen widgets for $1,200. Given this information, which of the following statements is true? There has not been a valid offer and acceptance, and therefore a contract has not been formed. Where an offer has been made by post, an acceptance by post will be effective when posted. As a general principle, which one of the following is the proper method of communicating acceptance of an offer? In the same form as the offer. Which of the following will not result in the release or expiry of an offer? The illiteracy of the offeree. The courts will never allow the remedy of specific performance where damages are considered to be an adequate remedy. On May 3rd, Mary offered to buy Harvey's house. The offer was stated to be open for acceptance by mail or telephone until 2 p.m. on May 4th. Which one of the following statements is true? If Harvey makes any substantial changes to Mary's offer prior to accepting it, Mary's original offer is terminated. John makes the following offer to Mary. I will pay you $500 to put a new rose bed in my garden. If Mary accepts, what is the result? An enforceable contract has been formed if an intention to create a legal relationship exists. On March 7th, Alan contracts, in writing, to sell his home to Bob for the price of $100,000. The sale is to complete on March 31st. On March 8th, the house is destroyed. Accordingly, there has been a frustration of the contract. Which one of the following is not a remedy for breach of contract? Rectification. Under the law of contract, which of the following is not an element of a misrepresentation by a seller that will entitle a buyer to rescind the contract of purchase and sale and claim damages? Correct answer: the statement must be one of opinion. Bernadette has agreed to purchase Steve's home for $438,000. However, before the sale completes, she discovers that she has been the subject of an innocent misrepresentation that materially affects the contract. Bernadette may go to court and ask for the application of which of the following legal principles? Rescission. If an offer is made by mail and the acceptance is mailed, when is the acceptance effective? When it is posted. Duress, in law, consists of actual or threatened violence or imprisonment. Avoidable contract is a contract that one or both of the parties can cancel. A owes B $1,000. B assigns the debt to C. For this to be a statutory assignment, 3 requirements are necessary. Which one of the following is not one of them? The notification from A to B must be in writing. S. A seller offers to sell a property to A for $50,000. The offer is to remain open for acceptance until noon the next day. At 11 a.m. the next day, B offers to buy the same property for $75,000 and S accepts. At 11:30, A accepts the original offer to buy the property for $50,000. Which of the following statements is true? 1. S has entered into a contract with both A and B. 2. S could have revoked the offer to A and avoided the problem. 3. S was entitled to accept B's offer. All of the above 3 statements are true. Anna is interested in purchasing Elizabeth's house. In an attempt to save money, instead of hiring a licensed home inspector, Anna thoroughly inspects Elizabeth's house herself and does not find any defects or deficiencies. After the sale completes, Anna discovers a major issue with the foundation of the house that will cost $55,000 to fix. As a result, Anna sues Elizabeth for failing to disclose the issue with the foundation. Which of the following is true? Anna's claim against Elizabeth for failing to disclose the foundation issue will likely fail if it can be shown that any qualified home inspector would have identified the issue.